Welcome to a CNBC Africa special. I'm Arnold Quizera. In today's conversation, we're going to be talking about the importance of intellectual property rights to artists, but also to implementers as well. Now, just to give you a little bit of context, now the impact of COVID-19 on businesses continues to be profound, and the conversation on the importance of IP rights seems to grow day by day across various sectors. Now, the importance of IP rights is ensuring safety, reliability, and effectiveness for consumers has never been in doubt, but could they also be detrimental for the growth of other sectors? Now, to answer these questions, we are joined by a panel of experts, starting with Mr. Richard Kaibanda. He is the Registrar General at the Rwanda Development Board, also known as RDB. We are also joined by Mr. Samuel Sangwa, who is the Regional Director, Africa International Confederation of Societies of Authors and Composers. Now, to be part of this conversation, you can tweet us at CNBC Africa or tag me directly at The Real Quizzer. Now, I want to start with you, Mr. Registrar General, Mr. Richard Kaibanda. Please explain to us what the importance of IP rights is.
The importance of IP rights is, in a few words, that they allow creators and innovators to reap from their efforts, their intellectual efforts. That is, if we start with a definition, these are exclusive rights that are granted to creators and innovators or inventors. Let's say if you come up with a song, you have invested in a lot of energy, time, and money. And then if you were not protected, you're not given rights to be able to enjoy exclusive right to use it, to authorize any use of it, then you would not be encouraged to come up with more songs. So the importance of intellectual property rights lies in these exclusive rights that they grant to the right holders, and basically they give the right holder exclusive rights for a certain period of time, depending on the nature of the intellectual property. And then this allows the creator or the innovator or the inventor to benefit from what they have invested and invest more in more innovation, more creation, and then we as a community at large, we benefit from that because we see new products coming on the market, new solutions being put at our disposal, solving different social issues and societal issues that we have. So globally, the protection of intellectual property rights benefit to the right holders, but also the community at large.
Thank you, the Registrar General at RDB. I want to bring Mr. Samuel Sangwa into the conversation, and that's because Mr. Richard Kaibanda has talked about artists. Have IP rights been effective to you as a person who leads an artists organization?
Yeah, when we are talking about copyright, and you really need to make a distinction between industrial property, this is related to trademark, to patent, and the like, and the other component, which is copyright, which basically grants economic rights to creators within what we call the artistic or the creative industry. And this is so important because we are talking about intellectual investment into the creation of artworks, ranging from music, audiovisual, books, movies, and the like. So you see how important is the copyright within the scope of creative and cultural industry. And I'm actually saying it quite clearly. We are talking about an industry. We are talking about jobs. We are talking about tax created. We are talking about circulation of product. We are talking about a business, basically. So copyright is at the heart of this ecosystem, hence the necessity to enforce it.
Samuel, I want to stay with you there. There's an argument that people or creatives might also be affected by the IP rights just creating some form of monopoly. What's your take on that?
That's not true. Copyright does not create a monopoly, because when we are talking about monopoly, you are actually thinking about excluding users or other creators from the creation. We really need to be understanding that copyright is the right to authorize. Sometimes there is this wrong perception that copyright is to prevent people to use, to consume artwork. It's actually the other way. Copyright is about allowing people to use a work. Let me give an example. You are a broadcasting station. You need content. You need music. Here, it's all about how am I going to authorize you to use my music in your broadcasting. So it's all about copyright. There's no monopoly, because at the end of the day, creators don't create to keep the artwork for themselves. They need to put it out there into the market. So copyright is only to organize this. How are you remunerating me for the use of my intellectual property?
Richard, I want to bring you back into the conversation there, and it's just a very similar question to what I've just asked Samuel. How do you differentiate between IP monopoly and IP rights acting as a barrier to entry for creatives?
Okay, thank you very much. I will not go far from what Samuel has said, because as he clearly put forward, it's not about monopoly. Yes, the way copyright or intellectual property in the general work, they grant exclusive right, but exclusive right, as some said, to authorize others to use, to authorize others to produce, to reproduce your work or your inventions. And this exclusive right, if we go into the other big part of intellectual property rights that we call industrial property, which Samuel also mentioned, trademarks, industrial designs, patents, utility models, etc. These are granted for a specific period of time. And during that period of time where the inventor, for instance, enjoys exclusive rights, they are entitled to license others to use their intellectual assets for economic growth, and then they are able to reap from what they have invested in coming up with a given invention, for instance, coming up with a given product with a new shape, or a product with the new qualities. But this is done against a cost for them, if I would say so, because, for instance, for an innovation to be granted a patent, you have to disclose that invention. The purpose of, one of the purposes of this disclosure is to allow others in the society to look at what you have invented and be able to add more and come up with more innovations that have more capabilities than yours. So rather, this encourages innovation, and as a society, we receive more products, more solutions to our problems, and then this is what actually has led to the level where we are. People building on what has been invented by others, and then coming up with more advanced solutions, products, and then the society's life being improved. If we look at, for instance, the trademarks, I may put on the market a product that is sold under a given name. For you to be able to enter the market, you will need to come up with a product with a different name, and so forth. So we have, for instance, certification marks, geographical indications that come with, that are used for products having certain qualities that are associated to them. So this rather contributes to having a diversity of products and services on the market, rather than limiting or creating a sort of monopoly. That's how I would approach it.
Richard, I want to stay with you there. We've had a few IP rights issue cases over the past 3 to 5 years. The law only came into play in Rwanda in 2017, and correct me if I'm wrong there. Over that period of time, there's been shutdown of some businesses. Is it fair to say that it has been effective?
Thank you very much. Maybe I will start with saying that the current law that we have was passed in 2009, and it was repealing a law that was there since almost the colonial period, because it dated back in the 60s. So in 2009, a law that was modern, if I may say so, was passed, and in 2018, there was an amendment to that law. But I would say that this law has contributed a lot and has been effective. If we look at the number of IP assets that were protected by the time it was put in place, and if we look at where we are today, and if I'm to give figures from the time, the colonial time up to 2009, we had only around slightly above 6,000 registered intellectual property assets, that is patents, utility models, trademarks, etc. But from 2010, for instance, you can see that we registered around 500 new intellectual property assets. And as of now, as of 31st December 2020, we had in total 24,496 intellectual property assets registered. So the increase in the number of assets that are being registered indicates that the law is indeed effective. And if I'm to talk about the cases that you've had of infringement, I would say, this is also an indication that people are becoming aware that this is an asset that should be given its value, that should not be encroached on. I'm saying this because you cannot claim, at least in our system and in regard to industrial property, you cannot claim exclusive rights and be able to enforce, to say that people have infringed on my rights if your rights are not protected, and protection is acquired for industrial property, that is trademarks, industrial design, patents, and utility models, etc. The protection is acquired through registration, and the registration is enabled by the existing legal framework. So I would say that the law has been effective, even if we would have to admit that in the case of Rwanda, as in many African countries, intellectual property rather is more or less a new concept compared to the Western world. But a lot has been achieved in terms of valuing this intangible asset.
Richard, I still have so many questions for you, but I want to bring Mr. Sangwa back into the conversation. Mr. Sangwa, many of your members are expected to have benefited from such a law, especially when it was revised, as Mr. Kaiband has corrected us in 2018. Have they benefited from the law yet?
Yes, they've benefited a lot. And just to put the discussion in perspective, I'm in charge of the Confederation bringing copyright societies under one umbrella, which is the International Confederation of Societies of Author and Composer. So we are actually talking about copyright societies where you have creators which are members. So basically, when we're talking about Africa, if we look at the year 2016, the All Africa Copyright Societies, and I'm actually talking about 32 African countries, were collecting more or less 59 million euros. That was back in 2016. And before the COVID, this number of societies collected almost 80 million euros. So you can see there is an increase of almost 20 million euros. And this means this money, these royalties, were distributed to creators. So you can see the increase. What does it mean actually? It means laws are being enforced. More awareness is being spread around countries. More measures are being taken to secure the intellectual investment return of these creators. So you can see that the creators are benefiting, but still, there is still a way to go because the potential of Africa is quite huge. Look today when you're talking about TikTok, when you're talking about YouTube, when you're talking about Facebook, the consumption of artwork is quite huge. So we still need to enforce much more efficiently so that creators can get much more return on their investment.
Mr. Kaibanda, bring you back. Sangwa is talking about creating implementation efficiency. Your office is responsible for that. How do you create more efficiency when it comes to implementation of these IP rights?
Okay. First of all, I would say that there are a number of institutions that are involved in the promotion and protection of intellectual property rights. The Office of the Registrar General, which is a department in Rwanda Development Board, serves as the National Intellectual Property Office, which is in charge of ensuring that we have systems in place to have these rights, first of all, protected. Protection, as I said, is acquired through registration in the case of Rwanda for industrial property. For copyright and related rights, you have rights by the time you have created the work, but for industrial property rights, you have to register. So the first step, the starting point is the registration of your intellectual property assets for the purposes of protection. So this is assured by the Intellectual Property Office, which is the Office of the Registrar General. And after registration, when it comes to having the rights enforced, the law gives the office, the Intellectual Property Office, powers to be able to handle intellectual property disputes through amicable dispute resolution mechanisms. That is mediation mainly, because arbitration is being handled by a different institution, Kigali International Arbitration Center. But as an office, as an intellectual property office, we do offer mediation services in case of infringement. As you might know, the court and the litigation has got for sure its own advantages, but also costs. So as an office, we do offer mediation. And among the cases that were reported to us, I would say that roughly half of them are resolved through amicable mechanisms. But in addition to the Intellectual Property Office, we have courts, courts of law that have powers to handle cases of infringement and have powers to award damages. So if you have, let's say, a trademark that is counterfeited, then the law allows you to go to the court and be able to seek damages if you are able to demonstrate the loss that you have suffered due to your trademark being counterfeited. In addition to that, the law allows the copyright holder to seek an injunction whereby the court orders the infringing person or company to stop those acts. And again, this is another remedy. I would also say that this is actually the law. Infringement on intellectual property rights constitutes also a criminal offense that can be prosecuted through the normal ways in which crimes are prosecuted. That is from the investigation to the prosecution and court taking a decision. We have also the customs services that have got powers to stop entry into the country of the counterfeited products. Let's say you have a product that is sold under a given trade name or brand, and someone tries to import counterfeited products that purport to be the same as yours. So the law allows the copyright, not the copyright, the intellectual property right holder to approach the customs services and request that those products are seized and they are not allowed into the market. And thereafter, with a court decision, the products, the counterfeited products, can be destroyed. So there is a number of institutional, a number of institutions that have got powers to intervene in the enforcement whenever intellectual properties of property rights of someone are infringed on. And I would say that it is our role as governmental institutions to invest into awareness so that people are aware of their rights and how and when to enforce them. But it is also the role of the right holders to make sure that they follow up on their rights, and whenever they are infringed on, they take the first steps to ensure that enforcement mechanisms are triggered.
Thank you. Very detailed answer there, Mr. Richard Kaiba. And unfortunately, we have run out of time. But before we let this conversation go, Mr. Sangwa, I want to bring you back into it with your closing remarks. And I want to bring a scenario that happened last year where between the artists and media broadcasters. Now, there was media broadcasters threatening, because of the IP law, threatening not to play local music. Now, how do you handle and how can artists benefit from such a scenario?
Thanks for the question, and it's really one of the hot topic currently, not only in Rwanda, but across Africa. The scenario being broadcasters stating that they are actually promoting creators, that they are very instrumental to make the songs, artworks being known. The problem we are having here is a radio broadcasting business model is based on the content. So radio needs music to attract audience, to generate money from advertisement, to brand themselves. So we are in a situation where the one who needs most the content is actually dictating his role to access the content. And I would like to come back to this as Mr. Richard Kaibanda said, enforcement becomes very important because we have an imbalanced situation where broadcasters are in a stronger bargaining position. And eventually, there is massive infringement of copyright by broadcasters. Just to give you an example, when we are talking about promoting, if we take the argument, by in Rwanda, are you actually promoting music from Jay-Z or Rihanna or Beyonce? No. Are you also promoting music of people who are already passed away? No. The problem we are having with broadcasters, we should say, is the economic model is based on the content, but they need to play fair vis-a-vis creators who actually fuel the industry with the content. Without music, very few radio actually would make it out there. So we need to find the right balance between the use by broadcasters and the remuneration which is due to creators, which actually provide the broadcasters with the content which they're exploiting. So this is the discussion, but it's all about enforcement. We need to have this discussion with broadcasters, making them understand the value of the content, the value of the artwork which they exploit, and which help them run their business. The same way they pay salaries, they pay electricity, they should also remunerate the creators which actually provide them with the very artwork which is at the heart of the economic business model.
Thank you very much there, Mr. Samuel Sangwa, Regional Director, Africa International Confederation of Societies of Authors and Composers. I also want to thank Mr. Richard Kaibanda, the Registrar General at the Rwanda Development Board, also known as RDB. Today was our conversation on IP rights and their importance. As always, you can tweet us at CNBC Africa, or you could tweet me directly at The Real Quizera. Have a great day.